Introduce myself. My name is Beth Hirschfeld, and I, along with my husband, Jeff Dover, started and are the principals of our family office, which is called Heirloom Family Office. So first, just our regular disclaimer, everything we talk about today will just be for information purposes and shouldn't really be relied on. To give you a little bit of context, my husband and I started Heirloom Family Office back in 2015 with a focus on opportunities, investment opportunities that are good for families and smaller institutions, but they're often difficult for families to either source or diligence. We've launched a number of companies around that to focus on these types of opportunities. To say the least, we've really been concerned about the volatility of the market since the beginning of our family office. So we really focused on uncorrelated opportunities that would perform in any type of market. And this is really what led us to the segment of investments that we focus on, which is legal finance. Because we figured that the law and lawsuits proceed whether the economy is good or bad, and often actually grow in down economies. We also really liked about this asset class that it offered good diversification to a portfolio because it truly is uncorrelated and has the opportunity to offer strong risk-adjusted returns with the added benefit of a strong community impact. It's one of those few investment opportunities that we found where you can earn a good return and feel good about yourself at the end of the day as well. Since we started litigation finance in 2015, we've done all sorts in the US and globally, and we turned our specific attention to this particular niche of UK litigation finance with a focus on consumer protection about 3 years ago. And as such, believe that it is
something's
actually
wrong with your presentation. The bottom part is not showing up.
Sorry? Oh, the bottom part's not showing up?
Yeah, maybe you need to put it in presentation mode. The last bullet point is kind of blocked out by blackness.
Let me see. That doesn't help.
Or maybe you just want to scroll as you do it, so that way people can see what your bullet points are.
Let me see if I make it a little bit smaller, does that help?
No, it doesn't look like it.
You have to make it.
Oh.
I don't know. I would just scroll it if you can do that.
Sure.
Does it scroll?
I'll try to do that. I'll speak to most of the points, so if something doesn't
Okay, great, perfect.
then hopefully we can cover it that way as well. So just to go back, I think since we started litigation finance back in 2015, we've done a wide variety of different types of litigation finance, both in the US and globally. And we turned our attention to a specific niche in the UK litigation market, which is consumer protection, focused in the UK about 3 years ago, and really believe that this is the best legal finance opportunity that we've seen in the 10 years we've been operating in this space. So as such, we've really turned our attention to this opportunity and building out this opportunity, and I'm really delighted to be with you to speak about it today. So within this opportunity, we actually offer both a debt structure with a fixed coupon and set term, or a fund equity structure that targets. We have a broad opportunity and a target exposure in the space. But before we get into too much of that, let me just step back and talk a little bit more about the UK consumer protection legal space and really why we like it. So we have a focus in the UK on sort of claims where there has been an obvious consumer protection breach. And what I mean by that is, let me give you an example. So we've all gone maybe to buy a car. And when someone goes to buy a car, they may speak with their broker about the financing options that are available. The broker has a fiduciary duty to offer them the best financing options that are available. Well, it turns out, maybe not surprisingly, that in the UK, many brokers actually had secret arrangements with the financiers where they would actually get a cut of anything that was above a certain rate that they could convince a buyer to take. So as a result, many car buyers for years were substantially overpaying for their cars because of these secret commissions. Now, this is a systemic problem. And as a result of that, the Financial Conduct Authority is actually exploring a redress scheme after the Ombudsman and several Court of Appeal decisions highlighted this huge issue in favor of claimants. So the reason we really like these type of claims are for a few different reasons. One, they fall under sort of established precedents or government compensation schemes, which really versus traditional litigation finance takes that question of law out of the parameters. And that's largely been settled. And this becomes much more a question of fact. So did the claimant actually suffer the breach that is not allowed? This is much easier, we think, to diligence. So in the case of motor finance, it would involve looking at the agreements and the financing levels that a claimant endured and comparing them against the averages or the allowable levels to determine whether or not there's a breach.
Hey, Beth, I have a question.
Yes.
So in the United States, because we've done a lot of litigation finance here in this group, a lot of litigation finance is over trade.
Yeah.
Right? And most of the time it's Asian companies, unfair trade practices, right? And that goes to some court in the South, and typically the South, like a patent violation, something like that. And Southern juries pass humongous awards.
Right.
Here it looks like what you're doing is you're not doing trade disputes, you're doing more regulatory. Is that correct?
Yeah. And one of the things that we're focused on is we focus on much smaller types of claims. So with respect to the motor finance as an example, these are individuals who went in to buy a car, tried to get financing from a broker, and it turns out that they were charged these secret commissions. And so as a result, ended up paying more than they should have been paying for that financing and for that car. So, one of the reasons
that's standard practice in the United States, by the way.
Oh, okay. Yeah. And actually,
sure.
The UK a few years ago actually put in sort of regulatory parameters around that. But it turns out that sort of since the years of, from 2007 to 2020, this was a systemic issue that was going on where people were being charged. And so now the government is in the process of implementing a redress scheme in order for people to be able to claim compensation for those breaches of the fiduciary duty that they were owed. And so one of the reasons that we really like these types of claims is that because if they are vetted, because they fall under sort of these very established precedents, the odds of success should be quite high and the adjudication quite short. And then the other thing that we really like about them is that because they are much smaller, the success of your financing, this allows us to do quite a large number of these claims. So currently we're doing, 1,500 to 2,000 of these claims. Your ability to generate a return or, the ability of sort of your investment doesn't fall to the success of just one claim. It really can be diversified across a number of claimants, a number of law firms, a number of different types of case types as well. So it just allows us to create. So we were just talking about UK consumer protection claims. And I was just talking a little bit about how, they are smaller in size, shorter in duration, and less on issues of law and more on issues of fact. So we like them because they're faster, smaller, and we consider them more reliable. So just as a very quick overview about what that means. So these claims, because they are pretty well defined, they can offer quite high win rates if you diligence them. And as a result, they can offer quite strong potential risk-adjusted returns. They are generally in an uncorrelated asset class. It's not really concerned with what's happening in the market because it's a legally related sort of situation. And because these financings are small, we can do a lot of them. So currently we're doing, over 1,500 of them. So it doesn't come down to this issue of one case or one law firm having to be successful in order to generate a return. So we really like that it's quite diversified. The other piece, especially in comparison to traditional litigation, is that we consider these sort of a shorter duration because they follow certain tracks in the court. And usually settle within sort of a 2-year period versus traditional litigation, which can take about 5 to 7 years. And the money is deployed and sort of starts working very early on. So in traditional litigation, you pay a lot of money upfront to sort of research and diligence the case, and then it sort of sits for a little while, and then you sort of have to pay more once the case goes to trial. But with these, because they are shorter duration, the money gets put to work right away and sort of starts, working very early on in the process. So we really like sort of all of those different aspects of the consumer claims legal finance.
So perhaps from the time that you get money in the door and you start financing this litigation, what's that timetable look like? Is it 6 months, a year, 2 years? And also, what's the likelihood of settlement? Because in litigation finance we do in the United States, almost all these litigations that are picked, they settle, right? And in almost no cases do they lose money, right? So can you just kind of define that for us?
Sure. So, I mean, it actually depends on the types of cases that we do. So because we do smaller types of cases, we can actually diversify across a number of different types of case types. And they will have a different trajectory and a different timeline for settlement. So for example, an undisclosed commission around a mortgage that's been missold, similar to motor finance, or motor finance could sort of take a year or two in the system, whereas something like housing disrepair, which is when they have in the UK councils that which are like government entities that offer affordable housing for tenants. If we are working on a housing disrepair claim, those will generally settle within 9 to 12 months. So it really depends on the types of cases that we fund, but at the same time, these cases, because they are smaller consumer protection claims, usually settle within sort of the 2-year mark. So we sort of forecast between 1 and 2 years. In terms of whether they settle or whether they go to court, you're right. A lot of them actually settle ahead of time, but some of them will end up going to court, and they have special tribunals in order to expedite that process. So unlike a lot of traditional litigation, which we talked about, which can sort of be for about 5 to 7 years, in these cases, they follow sort of expedited processes for trial. So if they do end up going to trial, then it's a much faster process.
Pardon me. Any questions?
Yeah, you have a question? Sure.
Many.
We have a question here.
Sure.
So in the UK cases, you do have the loser pay for all legal fees.
In the US.
In the UK.
Oh, sorry. In the UK. So it depends. It depends on what type of cases they are. But what we actually do as part of the element that we fund is called ATE insurance. So each of the cases have ATE insurance. So if there is a loss and there is a charge on those, then it is protected against that. But these kind of consumer protection cases, often for the claimants, they don't have sort of adverse costs associated with them. But we do have insurance. We do have ATE insurance to protect against that.
Yeah, 1 second. Let me give you my. Thank you. Another question. 1 second. Please be concise.
He wants me to be concise. That's like asking a fish to moderate his eating. What's the inventory turnover rate of the portfolio? What that tells me is how many small deals you need in order to be able to make money, and what is the spread between the cost of, on average, what is the spread on the cost of litigation or the effort versus the return?
Yeah, well,
From
that
the smaller
actually,
the case, the more number of cases you got to turn over. So the inventory turnover rate is the key.
Yeah, absolutely. And actually that does kind of bring me to my next slide. So that's a very good lead in. If you don't mind me sort of sharing that. Can you see this? I feel like this is not showing properly.
You're right.
Block again.
Just 1 second. I don't know what's happened since the reboot. Let me just get off of this and close up. Okay. So yeah, I mean, your point is absolutely taken. So one of the reasons, we find this very compelling, because it does have very strong returns and it is a fairly predictable market. One of the reasons that it is untapped is that you are dealing with the administrative hassle and the administrative burden of sort of dealing with so many different cases. So as I mentioned, we have over 1,500 cases that we're dealing with. And we actually so we work with partner law firms who curate the cases and then send them to us for our review and sign off on those. They have already done a review of the individual claims, but we actually review each and every one of the individual claims as well. And so reviewing those where there can be, multiple pages of claims and details and all those sorts of things, that just is a huge administrative burden. So what we did when we first started investing in this sector is we actually spent a fair bit of time and a fair bit of resource building the processes and specialized technologies to support us in being able to do that. So we have a full team that analyzes these opportunities and monitors them once we finance them. But it did take us sort of a substantial setup to be able to create customized processes and technology to be able to support that.
Keep on going.
Can you hear me okay?
Yes, we hear you. Yes.
Okay, perfect. So because we've been able to build this very large team, we can diversify across law firms and case types and be really on top of the legal developments. But that is really one of the reasons why, although this is a very attractive opportunity, it's just not really viable for sort of the individual investor to do on their own.
Email me honest.
So in terms of why we're able to access this opportunity, as I said, we've been doing this now for 3 years. We've built quite a large team that both go out, have been involved in the UK consumer protection legal sector for, multiple years. We do have a number of lawyers on our team. And we also have developed leading processes and expertise to really identify, assess, and manage these different opportunities. Because we have developed a reputation as a value-added funder in the industry, we've also been able to develop a number of strong relationships, which allows us to access and uncover some very compelling opportunities. As just asked in the last question, we've spent a considerable amount of time and money to develop proprietary tools and processes to automate these claims, so that we can review and keep on top of each of these, thousands of claims that we're funding. And as a result of that, we've also created rigorous due diligence processes, both in onboarding law firms, case types, the individual claims, and monitoring them once we've done those financings. So I know we're running quite behind.
Do you have a rating system on in terms of which which cases would be most effective and which are not? Where you could possibly win versus not win?
Beth, we have about 5 minutes.
Yeah, absolutely. So we do have a very rigorous process for deciding which claims we will onboard and which we will not. They obviously vary depending on the case types. For the claims that we do finance, we actually get external counsel as well to opine on them, and they must have a 60% or better chance of success in order for us to consider them. In addition to that, we have a number of other criteria that we do follow and make sure that they adhere to in order to consider them for funding. And each of the different claims are reviewed, and they all go to our investment committee for sort of a final review and sign off as well. So we have quite a multi-step process in determining which claims we will finance and which we will not.
Beth, there's an online question for you.
Oh, sorry, I don't.
Did you read the online
Oh,
question?
sorry. How many claims have you done year to date? Yes, so we've done about 2,000. In terms of winning, I'm not sure the exact number. I think we've settled over 500 of those. The IRR, so that's a very important one. So we target about a 31% IRR. We're currently tracking at just over 40%. So that's the gross. Obviously, there are, as you can tell, large administrative costs involved in that. But our ROI has been tracking above our target returns.
So what's the net IRR?
Sorry?
The net
The
after,
net IRR? I can't tell you that exactly. I'd have to get back to you on that.
is this in a fund structure or do you do special purpose vehicles?
So sorry. We currently have here, I'll just jump down to this to answer your question. So we currently have sort of two different ways that we do it. So one, we have a debt program, which is a secured notes program. It's a 3-year debt note with the option of a 13% annualized return or an 11% annualized return. In that case, we focus only on funding of fully insurance-backed claims, which means that all of our funding is insurance-backed. We also do offer a fund equity structure. We have one that is a broad strategy, which targets a number of different things. So here's an example of sort of the types of legal financings that we do. We do disbursement funding, which is funding sort of the specific claims disbursements that someone would incur in funding their claims. So that could be things like court costs, expert witness fees, and the insurance that we've talked about. We do secured lending for firms, so helping firms to undergo technology transformations and targeted growth. We have receivables factoring where we will acquire the receivables that a firm is entitled to help them manage their cash flows. We have cost advancement funding. So that's in the case where a claim has actually been won and the opposing sides are actually negotiating the costs involved with that. So we will help them bridge the gap for those types of situations. And then we will, in certain circumstances, do claims acquisition as well. And in that case, it is actually paying the acquisition costs for the law firms to take on those different cases. So we have that offering, which is a broad exposure to legal finance. Then we also have a special opportunity, which is focused specifically on the motor finance claims. In particular, there have been 3 Court of Appeal decisions in October. And as I was talking about the regulatory redress scheme, which has made a very specific opportunity around motor finance. So we have that one as well.
So the motor finance, is that against car dealers or against car companies?
It's against the financiers. So we're very specific about the types of defendants that we will finance claims against. So they have to be large defendants. So things like the council, which I talked about earlier, which is sort of a government entity that provides housing, or very large financiers, so banks and different players like that, where we feel that the potential of repayment is very high, and we have less of a risk of repayment risk. So with the motor finance opportunity, we are focused on sort of very specific financiers in the sector. So the one other thing, because I know we're quite tight on time.
Beth, I have got about 1 more minute. Maybe you can give us some party thoughts.
Yeah, perfect. So one thing I talked about at the beginning was that, we really like opportunities where there is the potential for a strong return, but also, a real community aspect of this. We like this because it obviously offers access to justice, consumer protection, really encourages good behavior in the community. And so, you can sort of earn returns and feel good about the opportunity. And then just as just to summarize, We really like the opportunity because it offers strong risk-adjusted returns. It's shorter than traditional litigation finance. It really comes down to sort of the operational execution and just rolling up your sleeves and doing the work to make the returns work, which is something that we always feel we're very well suited to do. So as a result of that, we've really invested in building a team here and have very deep industry expertise in the opportunity.
Fantastic. Well, listen, Beth, thank you so much.